Good morning, everybody, and welcome to this Wednesday's Global Talk at the Center for Global Studies. My name is Martin Bunton. I am the Interim Director at the Center for Global Studies as I fill in for the Director, Oliver Schmidtka, who is on a research leave in Europe this year. At the Center for Global Studies, we acknowledge and respect the Lekwungen peoples on whose traditional territory the university stands, and the Songhees, Esquimalt, and Saanich peoples, whose historical relationships with the land continue to this day. Before introducing our speaker this morning, I'll just review some housekeeping items. We ask that you please keep your microphone muted and your camera turned off until the question and answer period. And then in the meantime, though, during the presentation, do feel free to use the chat feature in the Zoom webinar to engage in any discussion and debate with other participants, or to post and share any links to other resources that you feel might be useful. After the presentation, there will be a question period. And at that point, we will ask you to turn your videos on to try to foster somewhat more of a collegial atmosphere for the discussion, although it's exciting to see so many people present in our room today, too. And of course, as you all know, the presentation is being recorded. So a tremendous pleasure to introduce Sarah Hungary today. Thank you so much, Sarah, for joining us. Sarah is an assistant professor at ECtHR Faculty of Law in the Department of Labor and Social Law. Her PhD she received in 2015, researching European human rights and gender equality. And more recently, she has worked on the Horizon 2020 Ethos project on creating a new integrated perspective on justice and fairness for vulnerable groups. Sarah, thank you so much for joining us today. Real pleasure to have you with us. I'll turn it over to you.
Thank you very much, Martin, and good morning to everyone here and there and here. And it's a pleasure being with you today. And actually, I chose my topic in a way which is relatable to everyone, because although most of my research is not really covering this area, but I said COVID vaccination and the related hardship is something we all experience, and we all have our own opinion about vaccination and general protection of public health. So I said that it's a topic which could be discussed by all of us, regardless of the background. And actually, I just thank you. The initial survey I just wanted to share is what, from a legal perspective, we consider as a compulsory vaccination. There are very few cases when you are lying in a hospital, but for example, when a doctor gets to you and gives you a jab, although it happened, for example, in one of the Bulgarian cases, but generally we talk about compulsory vaccination when it's forced by an administrative mean. For example, you receive a public health authority decree that you are obliged to get a vaccination. But from a human rights perspective, especially taking into consideration the case of the European Court of Human Rights, we also consider compulsory vaccination in cases when there's no such administrative obligation, but the claimants are forced in an indirect way. For example, one is deprived from entering his or her child to kindergarten, or you cannot travel, or you're banned from visiting concert houses or restaurants and so forth. So the focus is on a prospect of the disadvantage you may face if you are not obliged with law, even though it's not an administrative decree which is prescribing to do so. And just to give a very brief overview on the background, which made me think about this issue, is actually going back to the Hungarian legislation. But that's just to give you an idea on how compulsory vaccination is administered in the world. So in Hungary, after the third wave of the pandemic, the government issued, we had a special legal situation where the government actually could issue decrees in possible fields altering from the generally applicable legal framework. And as a part of that, in 2021, June 1st, the healthcare workers were obliged by this government decree to get the compulsory vaccination, and if they were not getting the vaccination, the contract was terminated by immediate effect, and the employment was ceased in 15 days of time, which is very detrimental compared to the regular termination rules applicable in Hungary. And based on this idea, a few months later, a similar legislation was issued for all public servants. However, the conditions were very different. So instead of the immediate termination, the employer must order unilaterally non-paid leave for public servants, and they had 1 year of time to think whether they want to get the vaccination or not. And for healthcare workers and public servants, both those who, for medical reasons, couldn't get the vaccination, they were exempted from that obligation. So as you could see, the legal source is the same, so that's a government decree. However, and the situation is by and large the same as well. However, one employee group faces much severe restrictions compared to the other, and the research interests of mine lay in why is it happening and what kind of answers could be given by constitutional courts, or in the future probably the European Court of Human Rights. So, and this is this is not moving now. But anyway, so the Hungarian legislation is just one example, because in most of the countries, regardless of the geographical location, issues some form of, oh, thank you very much, it's coming, some form of compulsory vaccination forms. Depending on the scope of persons, we can see regulations, I mean national regulations which are concerning everybody who is over 18 years. And that's just a few countries, but public sector workers and healthcare workers are affected in everywhere, or could be affected regardless of the national belongings. And sorry. Although in most cases the domestic legal system could provide some answers for that. For example, general courts or constitutional courts could, or actually they did review some of these regulations or legislations. But ultimately, at least for those who are members of the Council of Europe in the European region, can turn to the European Court of Human Rights, which is the ultimate forum for human rights issues in this area. And yeah, actually, you can see there are many countries coming from the Council of Europe scope. However, Russia is first was suspended by the Council of Europe, and then just renewed its membership, like I said, yesterday or the day before yesterday. So it also means that Russian people are now deprived to get their claims adjudicated by the Supranational Human Rights Forum, which is kind of depriving on an individual level. But nevertheless, there are many countries where citizens can turn to this special forum for human rights protection. And the court is judging the cases or deciding the cases based on the provisions of the European Convention of Human Rights. And actually, three articles are concerned in most of the cases. One is the right to life. The second is the right for private and family life, and the third is the freedom of self consciousness and religion. And this is why I said that since these topics are I think has a more general interest, and we can have a fruitful discussion afterwards. So I just quickly go through what is being analyzed by the court in these cases, and then quickly show you what was the decision of the Hungarian Constitutional Court and why I think it's not sufficient. And of course, so far, the European Court of Human Rights has not delivered a decision in COVID-related vaccination cases. However, there are quite a few decisions which are concerning, like generally compulsory vaccination, which are mostly related to cases of parents who were forced to get their kids vaccinated, and otherwise they would force like ban from kindergarten or elementary school and so forth. So we have a rich case law here, and I think most of the reasoning could be used in the COVID cases as well. So without further ado, of course, one of the most important issues is the right to life, and this is an absolute right which means that the state must protect individuals' life by two means. One is that the state should refrain from violating the individual's human rights. And second, the state also should issue or regulate in this area in a way that it prevents risk and protects the individual's life. For example, in case of a global pandemic. And the state's obligation is defined in that sense in the LCV versus United Kingdom case, when the court says that the state must protect individuals from any kind of hardships or risks which are known or should have been known by the state. And actually, one of the interesting legal questions is that what we should do, or should we do something with the possible side effects of any kind of vaccination? Because as we all know, and in most of the claims it is apparent that people are mostly afraid by the side effects which goes by any kind of vaccination. I mean, all medical treatment has a possible side effect, but for vaccination, especially for vaccination which were developed in kind of in a rapid process, not necessarily going through the same kind of scrutiny by healthcare authorities, these concerns are of course enlarged. However, in the previous cases, the European Court of Human Rights decided that Article 2 is not in concern when it comes to compulsory vaccination, because by the state-of-the-art status of healthcare protection, vaccinations by and large are capable to prevent epidemics and under the obligation of preventing or protecting people from risks that are known or should have been known, like vaccination is a very good way of protecting people from these kind of diseases. And that also true that arguing the court that one can experience some unexpected side effects, maybe even death in that sense, but it's still not in the scope of Article 2, because these are very rare cases, and these can happen with any kind of or after any kind of medical intervention. The right to privacy or the right to private life stands in the core of the arguments from claimant's side. Because of course, having a vaccination interferes with your bodily integration, and your consent must be given before you get the jab. However, this right is not an absolute right, unlike the right to life, so it could be limited by states, and the states have a very large margin of appreciation in that sense. And the court usually or routinely uses this test to see whether a restriction was in line with the European Convention of Human Rights, and this is a three-step test. For the first step is that the measure should be issued by or provided for by law. It's not necessarily just acts, but any kind of legal actions or legal measures which are applicable for everyone. The most interesting element is that this necessity test. I mean, it should not shouldn't go beyond what is necessary in democratic societies. However, what is a democratic society is an arguable question, but actually every country who is a party to the European Convention of Human Rights considers themselves as democratic societies and democratic regimes, regardless of what other countries or political systems think about them. And there's the third item of this test, which provides for the causes, the just causes, one of which is the protection of public health. So applying these tests to regular compulsory vaccination cases, the European Court of Human Rights came to the conclusion that it's not a disproportionate burden on, or not disproportionately restricting the right to privacy. And last but not least, most of the claims deal with the freedom of religion, actually, because some of the vaccination are using some kind of components which are or could be banned from certain religions. For example, if the material which helps to carry the necessary protecting materials within the injection are usually made from swine, or generally there are some religions which or there are some religious groups which believe that your health shouldn't be interfered by humans. It's a divine issue whether you stay alive or die. It's not something where humans can interfere. So there are different kind of religious biases or opinions concerning that area, and I think that's another very interesting question to see how your system or how your beliefs can influence your everyday decisions. And in that sense, the court is saying that if you want to prove that that getting compulsory vaccination is against your religion, then it must form a very integral part of your system of beliefs, and it must be concise, it must be serious, and it must be an important part of your religion. And in actually most of the cases, like in this most recently decided Wawrzycka case, all the applicants were mentioning that, oh, and by the way, compulsory vaccination is against our religious beliefs. But when the court asked questions that, okay, what forms this part of your religious system which denying to get a vaccination altogether, none of the applicants were able to explain that. So therefore, the court couldn't make decisions on that, whether it's serious enough to deal with that. But generally speaking, the court also argues that regardless of your religious beliefs, the legal system is applicable for everyone, and you cannot make general. I mean, generally, you cannot exempt one religious group or another from that, but it should be decided on a case by case basis, based on what is provided for by the claimants in terms of the religious beliefs and the seriousness of these teachings. And the final part of my presentation, and that's going to be the shortest, is concerning the Hungarian Constitutional Court's decision in these cases. So the Hungarian Constitutional Court also have dealt with compulsory vaccination, especially which is compulsory for children, and actually came more or less the same conclusion as the European Court of Human Rights. And it was arguing that, or providing for that since the law applies to everyone and the provisions of the Healthcare Act is not following any kind of religious teachings, and the question is not relating to the fact whether we believe in something or we're not believing in something, but it's a scientific issue. And as far as we know, vaccinations are very convenient ways to fight against diseases. So that was the essence of the previous decisions. And when the court decided on these very cases of the COVID vaccination related to healthcare workers, and in a later case for public servants, it argued that actually providing for compulsory vaccination, the state were acting to fulfill its positive obligation to protect the individuals against the spread of this disease, which is under the right, not the right to life, but the right to health under the fundamental law of Hungary. And Actually, the court is not there to decide whether something is good enough, medically speaking, or not. And that's actually a rare field because the Constitutional Court usually claims an all-encompassing knowledge on everything. So that's one of the few cases when the judges declare that they are not knowledgeable enough to decide whether vaccination is good or good enough to prescribe it. So that was a long decision in terms of like number of pages, but many of the interesting questions were not answered. And actually, I call everyone's attention to these questions because we can, I think, discuss these together, because at least I don't have a proper answer. I just have my own thoughts for that. So the first question which was not answered is the proportionality of these sanctions. I mean, if you remember this test which was carried through by the European Court of Human Rights, we could see that the legal obligation should not go beyond what is required in a democratic society. But in a democratic society, of course, there are many other legal obligations from the state side. For example, which are related to the right to work, to mention one of the most important things, and the ban on employment for those who didn't get the vaccination actually could cause the fact that these people are unable to get a paid job in their occupation, so they must do something else while the special legal order is withdrawn. But if they cannot get an occupation and cannot get a job under or in the occupation, they must do something in order to earn money. So it possibly increases the number of people who are doing undeclared work, which is which I think we all can agree that it's not a preferential situation. And also the economic consequences of this immediate termination, because compared to regular termination, these people are not enjoying a notice period, which is at least 30 days under Hungarian law. And after 3 years of service, you get some severance payment as well. So altogether, for example, if somebody is working for like 5 or 10 years in the healthcare sector as a public servant, they can lose up to 8 months of their salary because of this special terminational regulation. So that is probably not proportionate compared to the violation of the right what they do, namely that they are not willing to get vaccinated. And also these piece of Hungarian legislations are not clarifying the relation to other pieces of legislation, especially those who are protecting pregnant workers and mothers on maternity leave, because they are as sui generis causes for termination, and the legislation itself excluded its scope from the regular termination rules. So technically, anyone could be terminated because he or she is not willing to get the vaccination, including pregnant workers, disabled, mothers breastfeeding, and everybody. So that's an area which should require more scrutiny, I think. And the third one is related to Hungary or any other member states if more applicants are going to, more claimants are going to hit the court. The interconnectedness with the international law obligations. In Hungary's case, that's the European Social Charter. That's another piece of human rights instrument under the Council of Europe, which allows member states to inform the Commission that they are suspending temporarily the obligations rising from the European Social Charter, but it requires a specific notification, and the state must declare which are the specific articles they are they wish to adhere from. But Hungary did not issue any of these notifications. So technically speaking, the European Social Charter is still applicable in all cases. And for example, termination of pregnant women is just not possible under the European Social Charter, which provides for special legal regimes for these workers. So I hope I met the time frame and it was not too quick or not too boring or likely to follow the line of my states. And I think it's better if we start by just discussing what we also do at vaccination.
No, Sarah, thank you so much. So much information here about Hungary, but also this is all these issues very much still on all of our minds, aren't they? Sarah, would you like to sit or would you like to keep standing or whatever?
Whichever is more convenient for.
Great.
So I can maybe like do this.
Okay, I will too. I will. So we have people in the room, and we also have Kayla and Jody, if you could help if there's any chat questions. And if you'd like to, in the Zoom world, ask a question, if you could either put your hand up with the Zoom or turn your video on and wave at me, that would be, I'm sure we'll be able to catch you. Natalie, can I ask you to start us off? Thank you.
Hi, thanks very much. That was a really very informative presentation, and there's a lot to digest there. I didn't know any details of the Hungarian Constitutional Court decision, so that's really been interesting for me. I'd like to start by asking you a difficult general question. So I'm just interested in your thoughts on this, because as you said, the constitutional decision didn't address the issue of proportionality.
Yeah.
And that's really the thing that I think at least in a Canadian context, all of the government directives or threatened legislation concerning possible employment bans or employment restrictions associated with vaccination refusal, I think public concern and outrage and distress, such as, to the extent that there was such concern, really revolved around this issue of proportionality. And so I know, Hungary is not the only country in Europe that passed similar or that attempted to pass similar legislation. I'm interested in your thoughts on this issue of proportionality, just given your area of study, if you'd like to make some general comments about proportionality and vaccination requirements, because we know there's a whole suite of similar measures that have been put into effect and quickly withdrawn in lots of places. And I'm just trying to grapple with this when I'm teaching, when I'm teaching my students about the ethics of these kinds of legal efforts to enforce vaccination mandates. Very
sure. Thank you very much. So should I answer the questions one by one?
I think so.
Okay, great. So I think I can give you the very scholarly answer that it depends. It depends of what kind of employment situation we are looking at. Because, for example, the situation I think is very different for healthcare workers and for public servants. Because generally I think that the employer can play around and see what are the scopes of jobs where which must be filled by vaccinated people, because otherwise it's a threat for their health or the general public health. So for example, I guess a doctor or a nurse must be vaccinated because they are interfering with possible other contingent people. But there are many people working at the hospital, namely the administration or cleaners or whoever, which may not interfere with patients at all, especially regarding the administrative stuff. And under the Hungarian legal system, they are owned by the same piece of law. There's no alteration based on the job scope, whether you belong to or your situation is governed by one piece of law or another. So everybody is under the Healthcare Servants Act. And when it comes to people where interference with patients is not so frequent or it's not happening at all, and it's also applicable to some of the public servants, because public servants are so different from each other. You could be a bus driver or a school teacher or working for the government office, or you could be a minister. So that's like very different kind of jobs you are having. I think an individualized solution would have been meeting the proportionality requirements much more than a one-size-fits-all kind of rule. And for those where vaccination is really compulsory, and for example, they couldn't even be switched to another job because that's the only job what they can do. For example, if you are a surgeon, I think it's not feasible to think of you as a cleaner or as a receptionist in the near future. For them, still, the way of termination could have been made more proportionate. For example, applying the general termination rules, which provides for this notice period, which is paid, and the severance pay if you serve for many years, because especially with the severance pay, it reflects to the already worked years of yours. So if you are a nurse for like 20 years, why to take away this special bonus which is paid for your loyalty and for your hard work? So in that sense, I think that it's not proportionate at all, and it wouldn't have required that much budget for that either, because the amount of people which were affected by these laws who didn't want to get a vaccination, yet they're under the scope of either the healthcare act or the public servants, I think they were not more than 200 people altogether, because especially in the healthcare sector, but also for teachers, for example, the proportion of vaccinated people exceeded 90%. So that was not a huge amount of people which the government could have dealt with. So I think in their cases that it would have been proportionate and fair not to deprive them from the already gained required rights, for example, for the one for severance pay.
Thank you. Natalie, do you have a follow-up? Or okay, great, thank you. Tamara, can I ask you to turn your video on? Thank you.
You're muted, Tamara.
Here you go. Sorry. I think that's the classical you're muted Zoom thing, right? So thanks for your presentation. And every time I find it, I'm originally from Brazil and I'm a lawyer too. And when I hear stuff from Hungary, I think about so many stuff that is similar from Brazil. So yeah, always find fascinating. And but my question is a little bit, maybe, I don't know, how can, I think like my question is more like, we have experienced some sort of vaccination mandates before, like to get your child to go to daycare, you have to provide a vaccination record. Like you have to prove that your child has been immunized against all the other well-known disease, so you can get your child registered, right? And we have been living with this for a very long time, but it seems like now that we have a more complicated public health situation, because of course it's a pandemic, then all of a sudden it becomes like a huge thing to have to provide proof of vaccination. And it's like, as much as I, as a human rights lawyer too, I understand the side of like the individual choice and everything, but the vaccination is also like a collective thing. Like it only works if everyone does it, right? So it's always part of the pact or the agreement that we do with choosing to live in society. So I think like my question is more kind of like political in a sense of like, why? Like, is it a moment where we are living right now where we are just in this political conturbated context where it gets like all this mistrust around science? Or because why we don't have that energetic like crazy response regarding all the other things, you know? Like I don't know if I was clear of it.
I think you were clear. I mean, from my answer, you can judge whether you were clear or not. I think my answer is twofold. One is that these vaccines actually are very different from the already known ones. I mean, vaccination against measles exists for like 70 years. So these are very well developed and proven methodologies, how they interfere with your body, and they were tested for decades. Unlike these vaccinations, which were issued in a rapid or under a rapid process, and they were not really tested accordingly to these higher standards ordered. By the time the Constitutional Court delivered its decision in Hungary, the European Health Agency already approved these vaccinations, which means that they went through this 5-level test where the 5th level is actually applying it to humans and not only to mice. So these are safe vaccinations, but I think those who started to have concerns, they issued their legal claims before the approval was given from the European Healthcare Agency. So I think mistrust could be related to the process itself, how these vaccinations were developed. And second, the more political issue, I think the claims against vaccination for children were not so popular like 70 or 50 years ago, or even my parents, I don't think they ever think about whether it's really not compulsory or how they can sneak around the rules. So that was just a part of our life, that this is how things should be. And everybody followed the procedure, and everybody got the vaccination. And it was, I don't think, I mean, at least for Hungary, but I'm also turning to Esther, I don't think there was a sheet of paper which should be signed by our parents that they agree with our vaccination. So it happened in the school, we lined up at the doctor's office, and everybody got the jab. So that was not a privacy issue. It was not an issue. That was how things work. And I think as the society changes and people are actually more aware of their rights, I think that those who are concerned about these procedures have more voice. And their voice is much better heard because of the globalization of the media, and now we learn from each other through a Zoom meeting like that. What was the regulation in Brazil and in Hungary? So before that I think that was not simply possible. So those who disagree with certain legislation can better connect. They can share their issues. They can act together, or like I said, their voice are louder now. I'm not sure if that was the question, but that was my answer.
Yeah, thank you. Thank you so much.
Thank you, Tamar. Rod.
Well, thank you very much indeed. Very informative, very interesting to see the links with the Canadian case, and in particular, I guess, Article 1 of our own charter, and the questions as to what might be justified in a free and democratic society. I wanted to pick up on, it's the proportionality issue, but maybe in a slightly different context. You commented about Article 9 in the European Charter does not always guarantee the right to behave in public as you might be permitted to behave in private, that there are consequences to acting in the public sphere. I was thinking about the proportionality issue in terms of the public sector employer. I mean, all the public servants, some of them may be more public facing than others, but they're all employed by the state, and as they move around in the world, in the public sphere, they're creating risks for others if they're not vaccinated. So I wonder whether there's anything in the notion that even though the state might not be able to act in a commanding way with respect to private sector employment, there is a responsibility of the state as a public sector employer to try to reduce the risk to the public with the exercise of its influence on its own employees.
Well, to answer this question, I just review one other piece of legislation from Hungary, which is actually concerning the private sector employers, and which is none. So the government said that private sector employers deal with this issue as they wish to deal with it. So there was no special support, there was no legislation, there was nothing which could help employers to decide in that case. Moreover, if there was an employer who was more conscious about the health of their employees, or actually people who are interfacing with their employees, like any kind of stakeholder, clients, customers, whoever, they could they could make a statement that whoever is infected with COVID vaccination, they consider it as an occupational health risk, and they admit the liability for that, because it is assumed that they got COVID due to the performance of their job. And those employers who were like more cautious about the impact on society and how COVID affects their own employees' life, actually put a huge financial burden on themselves, because if something is acknowledged as an occupational health risk, and the employer is taking on the liability for that, almost all the costs which are occurred by this disease, like the hospital care, the medication, everything, is actually falling back on the individual employer, because the social security system is making the employer reimbursing the cost. So that's actually in other situations that works very well, because it helps prevention. But going back to your question, I think if the difference is so big between the private and public sector employers, and the obligation and the financial liability, although the jobs which are performed by a public servant or a private employee are not so different in terms of with how many people they are interfering, how they can spread the disease, whether they themselves are getting sick or not. I don't think these are justifying these big differences in legal regulations, and I think that could be another proportionality question, whether you measure the state as an employer and a small I don't know, family-owned bakery with the same measures, and the responsibilities and the cost have also be proportionate in that sense, but it was absolutely lacking from the Hungarian legislation. I'm not sure if that was the answer for your question.
Well, I'm not sure. Thank you. I'm not sure about the answer to the question in the end. I mean, it's one of these very gray areas, I guess, in which you do have that ethical balancing of the risk to an anonymous public as opposed to a cost to an individual. Yeah. Thank you very much.
Thank you, Rod. Jim.
Thanks. Two questions, Sarah. One is actually a follow-on from Tamara's. One thing that I think Tamara's question was getting at was that in your discussion of proportionality, your concern was very much the differential impact on differently situated individuals. It was very much an individualized analysis. But how does one handle the interaction between that individualized concern and broader, perhaps indirect impacts on the population at large? One of the things about human rights discourse is it tends to structure the relationship as a powerful state against an isolated individual. But the people who fall out of that analysis very often are the people who are not before the tribunal, but who are impacted by the actions. And so I think the problem is much more difficult than just an analysis of the individualized situation, but how does a tribunal keep within its field of vision the people who are not before the tribunal, especially in a case like vaccination, where the impact of, for example, children not being vaccinated for measles is not felt is not so much an individualized impact, but the potential impact of epidemics getting a hold in a substantial unvaccinated population. So I think there is a bigger challenge there that an individualized discourse doesn't get at, and that we really need to correct for. And I guess the second question is a kind of the converse of Rod's question, and that is that have you looked extensively at the treatment of these issues by private employers? Because it strikes me that in different societies, how vaccination questions by public employers versus private employers are treated perhaps says an awful lot about whether human rights really are just concerned with protections against the state, or whether they have anything to do with employers, about whether employers are going to be treated as individuals or treated as enterprises in which their workers have a stake. The kind of balance between public and private power, and taking private power seriously in the analysis of these kinds of questions. And I think that often we end up treating the private sector employer like the family bakery, where Volkswagen is not the family bakery, and the kinds of considerations that ought to apply in turn. It's hard to see why the human rights considerations should be at all different when we're dealing with Volkswagen versus state.
Thank you. These are very different, difficult questions. I tried to answer them together. So I think your first question relates to the general problem of whether labor-related human rights are fully fledged human rights or not, because the human rights violations are posed by a private party in that sense, and not by the state, because that's your employer who eventually fires you and not the state. So your claim is actually against your employer. So that's already a question whether that's a real human rights issue or not, especially when it is developed on a domestic field. And of course, the decisions of the European Court of Human Rights are individualized, and it's only applicable in that case. But of course, it has its considerations, which could or should be used by domestic courts as well. And what the European Court of Human Rights always emphasizes that they are just there to decide on individual cases, but the morals, the logic how a case is being decided is actually should serve as a blueprint for domestic courts as well. So they need to integrate their decisions into the domestic jurisdiction. So I think with implementing this way of thinking, what we can learn from the ECtHR can be spread for domestic cases, and at the domestic court is not going to be a human rights issue, it's going to be a labor case. So you are not deciding based on human rights principles, or if you just see whether the law allows you to do this and that. For example, whether the law allowed the employer to fire the pregnant employee who was not vaccinated. So that's a pure employment law issue. And I think for those who do not have access to human rights court, because it's lengthy, it's very expensive, and you need a proper lawyer who can feel your claim was there. I think that the situation is pretty much should be the same everywhere. So these people may not have a human rights remedy, which is in the dispersal court's case is like financial damages. So you get awarded like 10,000 euros in your case. But it's not enough, and of course it's not reaching too many people. So the aim should be not to treat these cases as human rights cases, but as regular cases. I think that could help individual claimants in a wider scope, because you can have access to labor courts much easier than to human rights courts, or it's much easier than to file a general application for the labor court than to file a constitutional complaint the constitutional complaint. So I think, although it has many human rights aspects, it should not be treated as a human rights question at courts. We should just follow up because I'm not sure whether I'm going toward the right direction.
Well, I guess you're right that the two questions are related, but I think they're kind of related this way, and that is that in our human rights analysis, we tend to have a model before us, all-powerful state, isolated individual. And that relationship dominates our analysis, as it did in your response. And does that kind of simplified version of the way the world works, is that enough? Is it enough, for example, if you have a situation where what this individual does, if it is generalized, so that enough individuals do not vaccinate because they prefer not to, they're worried about side effects, and they have on an individual basis, proportionality would suggest that, well, it doesn't matter if Joe Smith doesn't get vaccinated. But if the Joe Smiths are 30% of the population, then it really does matter. And how is human rights analysis capable of taking into account that kind of collective dimension, the ramifications of those individual decisions? Like, is that model too simple of it's just a state against a powerless individual? Because the state is in some ways acting by proxy for the massive non-represented people before that proceeding.
I think what you just said, lastly, the representation issue is one of the key things. I think in the long run, it should be part of general public discourse, because I think that was an emergency situation for all governments. There was no space, there was no time to involve people in this decision. That was really must to do because lives have to be saved. But if COVID remains also, or actually we start talking about general compulsory vaccination, not only COVID related, then it must need a much broader discussion on that. And these individual claims, which could be generalized because maybe people are afraid of the side effects, or they do not trust the healthcare system, or they are afraid of using vaccines which were not properly tested, or religious reasons, or so. I mean, but they can be generalized in a way, or at least could be grouped to areas of concern, and these could be and should be discussed on certain levels, either not necessarily just in the parliament, but on public hearings, right? So we could learn about the fears of the people, why they are not willing to do that. And if you know what's the problem, then the legislation can reflect back on that. But of course, it takes time and an awful lot of money, I think. So I don't think it's likely to happen soon. And I think, I mean, I'm not in a governmental position, but I guess like all governments now really hope that it's really over now, and the Delta variant was, or the Omicron variant was the latest, and it's about to die out, and we don't need to issue these cursive registrations anymore. But if it remains with us, or there's another one which is not COVID, but another deadly epidemic, then these concerns will reappear by time. So I think it's not again a human rights problem. It's more like how democratic or assumed democratic societies reflects on questions which concern like 20, 30, I don't know how many percentage of their populations. And just one more sense about your other question, which found that whether we can distinguish between the state as the powerful employer and the small family-owned bakery. I think the explanation has to be done from the individual's point of view, because as an employee, I have very little margin of appreciation what kind of job I would like to have. Whether I for example, if I'm a bus driver, whether I'm employed by the local government and therefore become a public servant, or whether I get a job at the private company. But as an employee, my interest is that I should be protected by the employer, and as an individual employee, I must have the same kind of rights regardless of the type of the employment, whether it's public, whether it's a private, whether it's a big company who can afford free testing and offer more protection, or whether I really work for a family business where they struggle with financials and so forth. So it must have the individual perspective when it comes to regulations, and not individual perspective from the employer point of view, but from the worker's perspective. It remains in an individual question, I think.
Fascinating. Natalie, I see you, but Rod, did you want to just quickly respond to that? No, okay. Well, microphone.
Sorry, I think Natalie had a response. I would like to comment further, but I think Natalie was waiting.
That's good. I just wondered if it was closely related. Natalie, sorry.
The comment I was originally going to make is now attempting to be closely related, because I'm so struck by the appositeness of the concerns raised by Jeremy about the fitness for use of a human rights approach to dealing with the exercise of private power in this kind of context. That I realized that the question I was originally going to ask might offer a path to a solution to this. Maybe solution is too strong. I was thinking as the presentation was unfolding about the interesting ways in which Article 8 of the European Convention on Human Rights have been used by courts, often twinned with the right to life, in environmental cases in Europe, and particularly thinking of how courts in the Netherlands have used the right to, Article 8 is the right to respect for family and private life, just to remind everybody else who maybe isn't so familiar with it. And I'm wondering if that right to respect for family and private life, if that's a possible ground on which some of the concerns raised by Jeremy might be fought. I mean, there might be an opening there for trying to bring in this broader set of concerned individuals impacted by the specific choices made. So for in the case of mandatory vaccination requirements, or of failure to comply with such compulsory vaccination requirements, that right to respect for family and private life might be a kind of, catch-all category that could represent interests of others than those before the arbitral panel. I'm just trying to, because to me, it's an interesting, it's been used in creative ways in European courts, and I'm afraid I can't put my finger on specific judgments just at this moment, partly because my computer's about to die and I'm trying to keep one thing open, but I don't know. I'm interested in what your thoughts are on that, and what maybe Jeremy or Rod would like to chime in as well.
All right. Thank you. I think it appears as a question of autonomy in vaccination cases. One is that the personal autonomy, that I want to decide what is happening with my life and what kind of medical treatments I'm willing to have. And in most of the vaccination cases, actually, it was reflected as the autonomy of the family to decide what is the best for their children. And for example, in this Wawrzycka case, Mr. Wawrzycka was the lead claimant, argued that as a fully fledged father of, I think, 4 kids, he can decide what is best for their kids. And also the court argued that it also has its limitation, because although in most cases that's the parents' choice, what kind of schooling they would like to provide for their kids, or what kind of church they follow, if they follow any, how do they dress, what do they eat, and so forth. But ultimately, that's the interest of the child which overrides the parent's autonomy in these cases, because the child's ultimate right is to be healthy, and that the parental right should be restricted in that way. That the kid must go to school. I mean, make the parent decide in which school, but that is compulsory for going to school. Make the parent decide whether what kind of meal they provide for the children. But if it's not nutritious enough, or it's not enough, or there were some cases when parents didn't believe in eating at all. So that of course it could raise a serious health or life-related questions for from the kids' perspective. So I think I'm not sure about the environmental law cases, because I never researched that area, but I think it's the Article 8 is in the cases which, like I said, are more reflected to compulsory vaccination programs of the children. It is like the shared power, the shared responsibility of the state and the parents, and taking the child's ultimate interest in the center. But when it comes to adults, whether they want to get a vaccination or not, I don't think these arguments can be used at all. So, of course, what we could learn from the European Court of Human Rights case law are not like 100% applicable or useful in COVID cases. So that's a big caveat here. But when it comes to individual autonomy for adults, I think it could also be restricted by the fact that if you are decided not to get vaccinated and you eventually become ill and you spread the disease and infect like 100 other people, then also your autonomy should be restricted in a way, not centering this time the child's interest, but public health and the rest of the society's interest. So maybe after all, this argument can be used in a way, I guess.
Jeremy, no, that's so. So I'll go to Rod and then back to Natalie. Oh, I see. Okay, and then I can raise Natalie's point in conversation. But first, Rod.
Well, this may be an observation that's not necessary for any of this group. I was stimulated by Jeremy's question about the question whether the individualized human rights analysis is enough in this situation. I was thinking about an analytical approach which is outside the legal discussion of proportionality, but looks at the question of risk analysis and risk decision making, and focuses on the challenge that's raised when you're looking at immediate, concrete, estimable costs that fall on an identifiable individual, and as against the risks that would be posed, uncertain impacts on a statistical individual, not identifiable, so that you're looking at a proportionality argument. The costs that you can see very concretely being weighed against a general impact in a public sphere that is hard to estimate, and the consequences are falling on people that you can't identify. So the risk balancing question there becomes very difficult, and the challenge as to how extreme a measure, how costly a set of measures would be warranted becomes very difficult. But as I say, that may be an observation that it isn't needed for this group.
Thanks, Rod.
So I think risk evaluation is very important, and especially if you consider COVID-19 as a possible occupational risk or occupational disease. And just an interesting thing, what happened today, very early morning Canadian time. we are applying for a grant with my research institute to see how this kind of risk evaluation plans could be done. What are the already existing informations which could be used by employers, and what is new, what we could learn through the COVID, and how we can transform it to an open source database which could help employers to gain this knowledge cost-free, or at least with very low cost, because I think the knowledge is there, it's just not accessible, and it's very expensive if you pay for an occupational health experts to come to your workplace and see what kind of measure is needed, what are the possible risks, and so forth. So if knowledge is generally free and accessible, I think that would be treated as or looked as a risk sharing once again between the state and between the employers, which could reflect to the potential cost of prevention as well. And if we win this grant, then maybe I come back in 3 years of time and talk about the experience of this pilot project. But the deadline for application was like 2 hours ago, and was 3 hours ago, and we worked very hard on that to finalize our application. So hopefully in 2 years of time, I can get back to you with better answers.
Oh, wow. Well, and thank you for finding time for us after just submitting that deadline. Goodness, yeah.
There was a surprise deadline.
Oh, yeah.
It's going to be next week.
Oh, goodness, you've had a busy morning.
Yeah.
Yeah. Oh, thank you. Esther.
I have a question from a totally different angle. So you mentioned that the government had to act very quickly to the whole pandemic situation, but it's not true for the courts, especially the constitutional type of courts or the European court that has a very long procedure. So it was not like we have to solve this problem by tomorrow. But as far as I understand, they actually accepted the government's argument about the whole scientific evidence behind the whole vaccine and all the data that the government submitted or not. Mm-hmm. So not in this situation, because that was a big first for all of us, but for the future, do you see any examples in the court's practice on the course that you mentioned, and especially in those countries where it's about the whole population, so it's really a core decision that will affect everyone, that is there any methods to involve scientific evidence in the court's decision and not just follow the government that also suffers from distrust from the population, because that would help to increase the court's legitimacy, especially in these cases that are really have this scope, as Jenny also mentioned.
Yeah, I think the European Court of Human Rights refused the claims which argued for the urgency of the claims, so they are not going to decide these cases in a speedy procedure. So that's the regular path, which, like I said, it would be like 7 years in some cases. So there's still a long way to go. But as for the Hungarian Constitutional Court's decision, I think that's very interesting that these were individual constitutional complaints. So the Constitutional Court didn't really look into the legislation itself, rather the individual situation, what kind of harm or disadvantage this person experienced. And the interesting thing is that although there were like altogether almost 10 claimants, I think from the healthcare sector, not all of them were actually fired. They were just afraid that they are going to be fired, and therefore there were no disadvantage what the Constitutional Court looked into, because they didn't lose their job. They were not deprived of their severance payment. For example, some of them were not even had the required service time. So it was more like deciding on the individual complaint and not about the law itself. So I think what is definitely needs more time and more scrutiny is to look into these regulations. However, again, from Hungarian point of view, once these regulations are coming out of effect after the emergency situation is over, the Constitutional Court is not going to look into them because it's not its own. They could, but they usually don't do that because it's passed away. I mean, it's not applicable anymore. So they say that it doesn't give any new perspective for constitutional analysis. So I think unless somebody files a real or starts a real constitutional procedure where the piece of legislation is at stake, or probably it could remain with us. I don't know, because some of the laws which were or the decrees which were adopted in the first wave of the pandemic, they were enacted in a special act, and they continue to be applicable. For example, that which related to telework or home offices. So all the individual decrees are not in force anymore, but that's a special act which kept these pieces of laws alive. So I think a lot will depend on the national legal situation and what are the actual scope of the claims, who are the applicants, what is the forum which is deciding whether it's an employment court, whether it's a constitutional court. So I think it's all very messy at the moment, and I think what kind of conclusions we can have at the end, it really depends on what kind of individual cases we can have at stake. And just a remotely relevant example, in the labor code, there's a very debated article about employers' liability, and usually we wait for the Supreme Court to give some directions or interpretations or what is understood by the lawmaker, especially that was a new piece of legislation, and we had to wait it like 7 years until the first decision came out. I work with some judges on an everyday basis, and of course we always ask with my colleagues, so what took so long? I mean, 7 years. I mean, imagine you are an injured employee and you wait 7 years for the final decision whether you get reimbursed for your lost arm, for example. I mean, that's a tremendous amount of time. But these judges were explaining that not all the claims reaching the Supreme Court are sufficiently dense enough to issue an interpretative judgment on that. So I think based on that, if the applications or the claims are not well written, if it's not thoughtful enough, so that the Constitutional Court can base or the European Human Rights Court can base the arguments on, or actually there are many cases which are not admissible because of formality issues. So a lot depends on what are we going to have at stake, what are going to be the basis of these decisions. So I cannot answer your question in short. Okay.
If there aren't other, I mean, it's not as though we can resolve these issues. If only we could resolve all these issues in this room. But so let me wind things down with some thank you. Sarah, thank you so much for coming and sharing all of this with us. This was fascinating.
Thank you very much for all the questions and remarks. I actually usually didn't experience such an intensive debate after my presentation, maybe because usually I'm choosing a more boring topics.
Well, I think one of the exciting things about these global talks for me here at the Center for Global Studies is not only are we guaranteed fascinating and deeply informed talks, but we can almost guarantee a terrific audience too and a good conversation. That's not always the case, right? So thank you, Sarah, for joining us. And thank you all for joining us either virtually or in the room as well. Very much appreciate all of this. My thanks again to Kaylee and Jody for their support putting this all together. Jody, I appreciated what you did using your screen there so we could get the new I think that's in some ways this was sort of experimental, right? We're sort of trying to bring people back into the room more, so I appreciate that as well. Before I let people go, let me just point out we have a busy couple of weeks ahead with lots going on. I hope everybody's familiar with this. tomorrow, not a technical global talk, but otherwise in the 10:30 to 12 slot, we're hosting Jeff Briscoe, who will present with his colleagues on a very important SSHRC-funded project on the Ghana Youth Video Program. So we're quite excited to be able to host that, and we hope that many of you can zoom into that. March 22 is World Water Day, and we're, as is the case every year, we always get some very, very exciting projects by Polis. This year they're presenting What's Beneath Our Feet, short films and insightful conversations about groundwater on World Water Day. So please zoom into that as well. And just so you know, on Tuesdays, we started to meet somewhat casually just in the foyer of the center's hallways for some contemporary events discussions. So right now, of course, they're focused on Ukraine and its global implications. But if you are around, please bring your coffee and join us on 2 p.m. On Tuesdays. I think that covers it. Okay, thank you all, and hope to see you soon.